Hello, my name is Adrian Koss, and today I will be presenting the Supreme Court case Grutter v. Bollinger from 2003. Okay, so here we have the case background. In 1997, Barbara Grutter, who was a white Michigan resident, applied to the University of Michigan Law School. She had pretty strong credentials, 3.8 GPA and a 161 LSAT score, but ultimately she was denied admission. The law school said that race was considered as one of the deciding factors in her admission process, and it was because they wanted what they called a critical mass of minority students so that students of color wouldn't feel isolated. Grutter felt this was unfair and unconstitutional, so she ended up suing the school, claiming violations of the Equal Protection Clause of the Fourth Amendment and Title VI of the Civil Rights Act of 1964. So this case raised three questions of legality. Whether or not it was constitutional for the University of Michigan Law School to consider race as a factor of admission, whether or not it violated Title VI of the Civil Rights Act of 1964, and if it was allowed under the Equal Protection Clause of the 14th Amendment. And in the judicial process that they underwent here, they answered all three of the questions, which I will also answer later on in this presentation. Okay, so key earlier cases cited in the argument and decision. So these cases are essentially precedents that were followed in order to help the court make the decision in Grutter versus Bollinger. Interestingly enough, the last one I have on this slide, Gratz versus Bollinger, was settled on the same day, so it's considered the companion case, but I'll get to that to the end of the slide. The first one was Regents of the University of California versus Back. In this case, the court decided that race was allowed to be a consideration in the admissions policy, but that racial quotas were unconstitutional, which means that you weren't, or the schools weren't, allowed to reserve a set number of seats for any minority applicants. The second case established the standard of strict scrutiny, which was Adirond Constructors versus Pena, which essentially meant that any policy that a higher education school had, or really a government institution, it had to face strict scrutiny, or the policy had to be very carefully designed or tailored. And the last one, Gratz versus Bollinger, like I said earlier, this is the companion case to Grutter versus Bollinger, and the court ruled it was unconstitutional, meaning what ended up happening was the policy that they had would grant automatic points for race, and they ruled against that. And this was actually used to help draw a line between what's constitutional and what's not going forward. The decision. So the Supreme Court ended up ruling 5-4 in favor of the University of Michigan Law School. Justice Sandra Day O'Connor wrote the majority opinion. She said that the Constitution does not forbid a law school, or any school really, from considering race as one small part of admissions, so long as the goal is to achieve diversity. She also stressed that Michigan University's policy wasn't a quota. They didn't reserve seats for certain groups, and instead every applicant was looked at individually, with race just being one small factor that could possibly give someone a slight advantage. She also added something pretty important. She said that race-conscious admissions wouldn't last forever, and she hoped that within about 25 years, which would actually be around 2028, which is around the corner from us, schools would no longer need these kinds of policies. So adding on to the previous slide, just to answer a couple of important questions. Was it allowed under the Equal Protection Clause of the 14th Amendment? And just for your reference, the 14th Amendment says, "No state shall deny to any person within its jurisdiction the equal protection of the laws." Meaning, the government has to treat people equally under the law. In this case, the court ruled that promoting diversity in higher education is important, and that the University of Michigan's plan was carefully designed without quotas. So it was, in fact, allowed under the 14th Amendment. And the next question is, did it violate Title VI of the Civil Rights Act of 1964? And again, for your reference, Title VI says that no person can be discriminated against based on race, color, or national origin in any programs or any activity that gets federal funding. And in this case, the court ruled that no, Title VI follows the same standard as the Equal Protection Clause mentioned above, and it was found constitutional, therefore it did not violate Title VI. So moving on to cases that cited Grutter versus Bollinger. One of them is Fisher versus University of Texas from 2016. The court essentially reaffirmed that race can be considered in the admissions process, but it ended up placing higher scrutiny on the process itself. It made schools show whether or not their policies were narrowly tailored and still necessary. And lastly, one of the most important ones, which was a huge turning point for affirmative action, was the case Students for Fair Admissions versus Harvard/University of North Carolina, 2023. The court actually ruled that race-based admissions was unconstitutional, and it overturned the decisions made in Grutter versus Bollinger, essentially ending affirmative action in higher education. So after about 2 decades of Grutter versus Bollinger helping to set the precedent for how colleges could design their admissions policies, it effectively, ended with this last case, Students for Fair Admissions versus Harvard/University of North Carolina, 2023. So to conclude my presentation, Grutter v. Bollinger upheld affirmative action by allowing schools to use race as a factor in their admissions process. But following the conclusion of the Supreme Court case, Students for Fair Admissions v. Harvard/UNC in 2023, the court reversed course and moved away from the precedents set in previous cases, which means that Grutter v. Bollinger is now an important historical case.